Hello?
Hello,
Hello?
we'll be starting in just a moment, okay?
Okay.
Okay, glad I got connected. Thank you. Good afternoon, ladies and gentlemen. My name is Judge Law, and we are going to begin with our Fulton State Expedited Accusation Calendar. These are a list of misdemeanor criminal cases in which individuals, after being arrested, have now been formally accused by the Solicitor General's Office of Fulton County, which is the prosecutor in this particular case. After the formal accusations have been filed, the case is now before the state court, and this would be the defendant's initial appearance before a judicial officer. If you have charges pending against you, please remember that you have a right to remain silent. Anything you say in open court or during the course of this virtual court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one of our attorneys from the Public Defense Office or the Conflict Defense List will be representing you. Okay, I see that we have a couple of folks in courtroom 2, so let's begin there. Who do we have, please?
Position number 1, Mr. Braggs.
Okay. Mr. Cameron Braggs is case number 22 CR 005356D. Mr. Braggs has been accused of criminal trespass from August 11th, 2021. And Mr. Braggs, you've been advised of your right to remain silent. Your attorney is going to be Miss Johnston. Okay, there we go. Thank you. All right. Ms. Harrison, good afternoon.
Good afternoon, Judge. I have 19 cycles, last arrest, June of this year, criminal trespass in Fulton County. No disposition listed in that arrest. Record does indicate an open case pending for terroristic threats and acts and obstruction of law enforcement officer and simple battery against police officer, 22 SC 180868. Record indicates one failure to appear and a total of 14 convictions between 2014 and 2022 for criminal trespass, disorderly conduct, or theft by shoplifting. Nothing further to add.
Thank you, Ms. Harrison. Ms. Alexander, good afternoon.
Yes, good afternoon, Judge. Good to see you again.
You too. And what's your recommendation?
Yes, Judge, the state is going to recommend a $10,000 surety bond with conditions of an MHET, a stay away from all Georgia Tech property in compliance with his lifetime criminal trespass warning that was issued. Of course, Judge, no alcohol, drugs, or weapons while out on bond. Judge, briefly, on August 11th, 2022, law enforcement were dispatched to the Georgia Tech's Clow Undergraduate Learning Building at 226 4th Street, Northwest Atlanta, Georgia, in reference to a suspicious person. The defendant was initially found on the 3rd floor of that building and was recognized as having been previously criminally trespassed from that location. When officers made contact with the defendant, he did admit to being on that property. An RMS systems check did reveal that the defendant had a current criminal trespass warning in effect until 2026. And of course, that was for the entire campus. Judge, the state is also seeing, in terms of this criminal history, it matches and mirrors what pretrial has with 14 prior convictions for criminal trespass. Clearly, the state feels that this defendant poses a significant risk of reoffending, obviously in light of that criminal history, and does pose a significant risk and danger to the community, Judge. So for those reasons, we are recommending that $10,000 surety.
All right, thank you. Ms. Johnston?
Good afternoon, Judge. Mr. Braggs has lived in Florida in Georgia for 4 years. I used to practice in Florida, so I messed up there a little bit.
Someone's reminiscing. Okay.
Sorry. He has lived in Georgia for 4 years. He cannot afford a $10,000 bond. We would ask for a $1,500 bond. And would ask for a signature bond if possible, as he is not employed right now and has no way of paying a $10,000 bond. That would be effectively no bond in this case. He is currently unemployed and is currently homeless, which leads to the ongoing trespass issue. And we would just ask that Your Honor takes into consideration his finances and current state of living while setting bond.
All right, thank you. Yes, there is case law out there that the financial situation of a defendant must be considered in addressing bond. The other factors to be considered is the defendant's likelihood to reoffend. Just looking at his Fulton County book-in sheet, he was booked in, and this is just the recent ones. He was booked in on June 28th, 2021, July 16th, 2021, December 7th, 2021, January 27th, 2022, February 22nd, 2022, March 5th, 2022, April 19th, 2022, May 25th, 2022, June 2nd, 2022, and now August 12th, 2022. Mr. Braggs, I'm not certain if you just miss us horribly, but the bond presently is going to be set at $2,000. It's going to be a $2,000 surety bond. You have to stay away from the entire campus of the Georgia Tech University. No alcohol, drugs, and weapons. And your next court date is going to be, is it the 25th, Ms. Bridgewater?
Yes, ma'am, it is.
All right, thank you. Next case.
Number 3, Mr. Graham.
Did he say Mr. Graham, number 3 is next?
Yes, Matthew Ebenezer Graham.
Okay, thank you.
This is case 22 CR 0053588A. Mr. Graham has been accused of criminal trespass and damage to property, criminal trespass, transmitting a false report of a crime, fire, disorderly conduct, and I believe those are the 4 charges against him. Mr. Graham, you've been advised of your right to remain silent, and your attorney is going to be Ms. Johnston. Ms. Harrison, any priors?
Judge, 34 cycles with history in Georgia, Alabama, and Tennessee. Last arrest was July of 2021 for theft by receiving stolen property in Spalding County. No disposition listed in that arrest. Record indicates 11 violations of probation, 2 violations of parole within the past 10 years. Misdemeanor conviction, 2017, obstruction of law enforcement officers, and 2 misdemeanor conviction for disorderly conduct in 2015, and a 2011 battery misdemeanor conviction, a 2014 and 16 felony conviction for possession of methamphetamine. Nothing further to add.
Thank you. Ms. Johnson, excuse me, Alexander?
Yes, Judge, thank you. As it relates to count number one, criminal trespass and damage to property, the state is going to recommend a $2,000 surety bond. As it relates to count two, criminal trespass, the state will recommend a $2,000 surety bond. As it relates to transmitting false report of a fire, the state is going to recommend a $5,000 good bond for that, Judge. And for disorderly conduct, count four, the state is going to recommend a $1,000 surety bond for a total, Judge, if my math is correct, a $10,000 surety bond with conditions of the MHET, two anger awareness classes, no further contact with the property owners in this case, Mr. Janesh Patel and Mr. Bipin Patel, a stay away, Judge, from 311 Cortland Street, Northeast Atlanta, Georgia. That is a Motel 6. And of course, no alcohol, drugs, or weapons while out on bond. Judge, briefly, on August 11th, law enforcement were dispatched to this Motel 6 in reference to a suspicious person. When they arrived, they met with the owners of the motel, who advised that this defendant entered the motel and asked the front desk to essentially contact law enforcement, for which they did comply. The defendant then advised that, quote, people were after him. The defendant was then observed running through the hallways. He grabbed a fire extinguisher and deployed that fire extinguisher. He then pulled the fire alarm on three separate instances. Guests were told to stay in their rooms because there, of course, was no fire. The defendant then grabbed a second fire extinguisher and struck it on the front desk door and also the motel, some of the motel doors, of course, damaging those doors. He then left with one fire extinguisher in his hands. He jumped a fence into the parking garage of the motel and was eventually seen behind flowers on the patio with a fire extinguisher. And of course, the defendant was then arrested. Judges, you've already heard from pretrial. This defendant is a multi-state offender. He's a convicted felon. He's got 11 violation of probations. He's got a very recent arrest. The state, of course, feels that this defendant does pose a significant risk of reoffending, a significant danger to the community. Judge, we're asked, especially on that $5,000 surety bond, we're asking for that, Judge. Obviously, the state takes these types of crimes very seriously, particularly in light of COVID, when resources are limited with our first responders and things of that nature, Judge. So for those reasons, we're asking for the $10,000 surety bond, Judge.
Thank you. Ms. Johnson?
Yes, Judge. Again, my client is indigent, so a $10,000 surety bond would effectively be no bond for him. He would not be able to pay that. He is self-employed and does various work. He's a sort of jack of all trades, and he is also in the process of trying to move into the Athens area to live with his aunt, Miss Joanne Adkins, who is his support system, and he wants to move there in order to try and get his life back on track. I tried to reach out to her this morning, but I wasn't able to make contact. But hopefully that will resolve itself. We would be asking for a signature bond in this case so that he can be released. He also is hearing impaired and is in poor health, so being in the jail is very difficult for him. So that's all from defense, Your Honor.
All right. I didn't realize he was hearing impaired. Deputy, have you been relaying the information to him?
Your Honor, he's hard of hearing some of the stuff you're saying, and he's just asking me what she was discussing, like a bond.
Some of it I don't understand.
Well, if he doesn't understand, does he assign?
Actually, because it's hard for me to hear. I didn't understand.
Speaking to the mic. Speaking to the mic.
I said I was asking him the question because I didn't hear everything that you said, and I asked him what were you saying, and I couldn't understand what you were saying in my hearing. So I asked him.
Deputy Burgess, is that you?
Yes, Your Honor.
Oh, all right. Good to see you, sir. Is the defendant got the use of a hearing aid?
I didn't hear everything that she had said, so I was asking him the last.
He has some trouble hearing when they talk low. So that's when he was asking me what Ms. Johnson is saying.
All right.
Could we do a live transcript for him? Would that be possible?
Let me see if the host is able to because we were not told about the hearing deficiency, so I did not proceed accordingly. Has been enabled. Who can see this? All right. So it's been enabled on again. Okay. Mr. Graham, can you see the? I'm assuming it has to be.
Yes, ma'am.
Okay, you've enabled can the defendant see the captioning on the screen?
Yes, Your Honor. He's looking at it now.
All right. Mr. Graham, my name is Judge Law. Did you hear me advise you of your right to remain silent and right to an attorney?
Yes, ma'am.
And did you hear the did you hear the prosecutor describe the charges and that they are seeking a $10,000 surety bond?
Yes, ma'am.
All right.
Hmm.
And did you hear your attorney's response?
Yes, ma'am.
All right. Would you like any of the attorney's statements repeated?
No, ma'am.
You
All right.
I really record.
Okay. So let me set if you are satisfied that you've heard everything, I'm going to go ahead and set a bond right now. Do you understand?
Yes, ma'am.
On the criminal trespass and damage to property is $2,000. The criminal trespass, transmitting a false report of a fire and disorderly conduct are $1,000 each. His total bond is $5,000. That is going to be a surety bond. He is to stay away from 311 Cortlandt Street in Atlanta, Georgia. He must stay 200 yards away from Motel 6 at that location. Do you understand, sir?
Yes, ma'am.
You are to have no contact with Dinesh and Bipin Patel, who are the owners or employees at that location. No illegal drugs shall be consumed, no alcohol, no weapons, and no firearms. The next court date is August 25th.
Yes,
Thank
ma'am.
you. Thank you, Officer Burgess.
You're welcome, Your Honor.
And then we got number 10, Mr. Unijay.
Thank you. Mr. Daniel Unijay, sir, can you see and hear us all right?
Yes, ma'am.
Your case number is 22 CR 005-361E. You have 6 misdemeanor charges against you stemming from an August 10th, 2022 incident. The charges are driving with a suspended license, failure to use proper turning or signals while driving, no seat belt, fleeing or attempting to elude a police officer, reckless driving, and driving without a valid license. You have been advised of your right to remain silent, and your attorney is Ms. Kim. Any priors, Ms. Harrison, especially if you have his motor vehicle record?
I don't have his motor vehicle record.
Any suspended license or reckless driving or DUI in the last few years?
One moment. He has a 2017 driving while license suspended. No disposition listed on that.
All right, thank you. Mr. Borker, good afternoon, sir.
Afternoon, Your Honor. The state's asking for a $15,000 surety bond. I understand that comes looking a little high with some sticker shock, but it's simply $2,500 for each charge. So when you aggregate it, it comes up high, but it's because the defendant did this to himself, and what could have been just a normal traffic stop turned into a $15,000 surety bond with $2,500 each, along with the conditions of no driving, enrollment in the anger awareness program, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, the defendant was driving rather erratically in between lanes and without a license plate. When the officer initiated a traffic stop, the defendant actually did have his license plate. It was just inside his car. which he presented to the arresting officer. Check of the license plate showed that the registration was good, but the defendant did have a suspended license. That's when the arresting officer called in for some backup, and then the defendant promptly left the scene, driving off at a high rate of speed. The officers did not give chase out of the safety for the public, but the defendant later returned to the police station. And at that point, the defendant began making threats to the officers. He said that he was going to shoot them. He informed the officers that they would die behind the badge. Felony obstruction and terroristic threats warrants were taken out for that incident. But this defendant, his license was suspended for a previous FTA. So we've already seen his inability to cooperate with judicial orders, and he's placing the public at risk. So that's again why we're coming in at a $15,000 surety bond, $2,500 each. Nothing further from the state.
Ms. Kim?
Yes, Your Honor. Mr. Unije is 25 years old, Your Honor, and he was born and raised here in Georgia. He has a mother here in Georgia, and yet financially she cannot support and pay for the bond. He has actually, on the day that he got into trouble, he was just getting out of the job interview at the airport, and he has not had a job for the last 1 month, and he's afraid that he's not going to get a job at this point because of this arrest incident. He's also residentially challenged as of now, and he would like to request for signature on bond, and yet because of the past histories and current situation, if Your Honor is not inclined to give him a signature on bond, please consider that his felony charges, that theft, threat, a terroristic threat, which was considered as a felony, he already has $8,500 surety bond for that. So if we add another 15,000 surety bond, it's almost like having a no bond for him. Financially, he is not able to afford that at all, and he is currently enrolled at Georgia State University, and he is pursuing his bachelor's degree to become a pharmacist one day. And we would like to request lower bond, significantly lower bond, like $1,000 maximum, Your Honor. Thank you.
Well, in full disclosure, Mr. Unije is no stranger to me. I do believe that he's had a couple cases before me in the past. On the suspended license is going to be $1,000. On the all the charges are going to be $1,000. The suspended license, the fleeing, attempting to elude, and the reckless driving are surety bonds. The turning movement, no seatbelt, and the driving without a valid license are going to be a signature bond through the jail. His total bond is $6,000. It is a split bond. No driving unless he has a valid driver's license attached to himself at all times. And I guess then any stay away and no context, that's really with the felony case. Thank you.
Thank you.
The next
Thank you, Your
court
Honor.
date is August 25th.
Yes, Your Honor.
Next case, please. Yes, Mr. Unije, what is it?
Okay, so
Mr. Unise, I strongly recommend you to stay silent. If you have any question, I'll call you and we can discuss. Please, you have every right to remain silent. We want to protect your right.
I understand that. I'm not gonna talk about my charges. I just wanted to ask the judge. So I leave out my car. I was living out of my car, and as my lawyer said, I was coming from a job interview.
So you're discussing the case then?
I just want to see if the bond could be lowered further than that, because I was trying to go to school. I was trying to get enough money so I can be able to go to school and get a job where I can take MARTA instead of driving, because I know my license is suspended. So if I get a job at the airport, I can take MARTA and I wouldn't have to drive. And I was living out of my car, which is why things allegedly happened. If you understand what I'm trying to say.
I do. That's why I've given you a split bond. The prosecutor is asking me for a $10,000 surety bond. But considering the circumstances and considering your criminal record history, that I've presently given you a $3,000 surety bond, and the other portion of the other 3,000 is a signature bond through the jail. And that's the lowest I can go. This is what happens when you have repeated criminal cases and judges remember who you are.
Yes, ma'am.
All right. Now, you may not remember me, Mr. Uneje, but I do.
Yes, ma'am.
All right. So the 3,000 surety bond is the lowest I can go.
Okay.
And try to avoid this problem.
Yes, ma'am.
Thank you.
Well,
Number 2, Mr. Kirkson.
This is State versus Thomas Kirchen Sr., 22 CR 005-365G. Mr. Kirchen is accused of simple battery, domestic violence, hindering a person from making an emergency phone call, and terroristic threats. And this is from August 12, 2022. Mr. Kirchen, you've been advised of your right to remain silent, and your attorney is going to be Ms. Johnston. Any priors, Ms. Harrison?
18 cycles with history in Oregon and Louisiana. Last arrest was July of 2021 for assault in the 4th degree out of Oregon. That was a misdemeanor conviction. It appears he's still on probation on that arrest. He has 24 months probation, August of 2021. He has a 2014 domestic abuse battery, 2 separate misdemeanor convictions out of the state of Louisiana, and a 2018 battery in the 2nd degree in Louisiana. Nothing further.
Thank you, Ms. Harrison. Ms. Alexander, please.
Yes, Judge, thank you. The state is going to recommend, Judge, a total bond of $10,000 surety. So as it relates to the simple battery family violence, the state's going to recommend a $5,000 surety. As it relates to the hindering charge, Judge, the state's going to recommend a $3,000 surety. And as it relates to the last count charge there, the terroristic threats, a $2,000 surety bond, Judge, making that a total of a $10,000 surety with conditions of a 2-day anger awareness class, no further contact with Shakira Muskelly, a stay away, Judge, from 336 Archer Way Northwest, apartment 336B as in boy, Atlanta, Georgia, a third-party transfer of the children, Judge, and of course, no alcohol, drugs, or weapons while out on bond. Judge, briefly, this was an incident that arose from the victim essentially turning on lights. On August 12th, 2022, law enforcement were dispatched to the incident location in reference to a dispute. The victim advised the defendant got mad at her when she turned on lights in the living room while the defendant was sleeping. The defendant began to curse her out, and she asked the defendant to leave based on her knowledge of prior instances of violence between these two parties. The defendant then grabbed the victim by the neck and face, threatening her and cursing at her. The victim then attempted to call 911. The defendant grabbed the victim by the hair, pinned her to a wall, and while she was pinned, the defendant then proceeded to slap her in the face. The victim was able to finally break free. Judge, he attempted to call 911 again on her house phone, but the defendant then pulled the cable line off the wall socket, essentially preventing her from calling 911. The victim again broke free, was able to call 911 on a cell phone. Judge, our office did make contact with the victim in this case. She did not want to speak, but she indicated to our office, Judge, that she feels exceptionally unsafe with this defendant. There was a recent, my understanding and the office's understanding is that there was a report, an incident that was recently reported as recent as last Thursday against these two parties. The victim advised that the defendant has threatened to kill her on occasions and has definitely been abusive to her in previous instances, also in front of these children. My understanding, Judge, is that these two parties do share 2 children together. As you've already heard from pretrial judge, there is a significant history of domestic violence stemming from not only our jurisdiction, but of course, out of Louisiana. Judge, that is the basis for the $10,000 surety in this case, Judge.
Thank you. Ms. Johnson?
Yes, Judge. Mr. Kirchun does work in transportation. He's worked at the same transportation company for 4 to 5 years now. He has lived in Georgia for about 10 years. He would not be able to afford a $10,000 surety bond. We would ask for a bond set in your honor's discretion, but something more in the realm of $3,000 would be more fitting for Mr. Kirchun. He would not be able to afford $10,000. And he does not have anyone at the moment who is able to bond him out. He does have children that he does provide for, as the state just explained. So that's why it's important for him to be able to get out so that he can go back to work, and he would be able to go back to work if he was released.
Understood. Thank you. On each count, it's a $2,000 surety bond. That's a total of a $6,000 surety bond. No contact with Shakira Mascali, which means that he is to stay 200 yards away from her, not communicate with her in person through a phone, a computer device, or through a third party, and also not through social media. He's to have no contact with the minor children in question with whom he shares with Ms. Mascali. If he wishes to have visitation and or any type of custody with regards to the children, he needs to file a legitimation action in the appropriate superior court and get a court order to establish visitation and custody. No alcohol, no drugs, no weapons, and no firearms. He cannot return to 336 Archer Way at apartment 336B in Atlanta, Georgia. He's to stay away from the entire complex. If he has personal belongings at that location, a neutral third party can be selected by Ms. Mascali to come there and pick up his belongings for him. But I'm not permitting a one-time visit to retrieve his personal belongings. His next court date is going to be August 25th. Thank you.
Yeah, we got number 6, Mr. Jones.
This is Thomas Anthony Jones Jr., accused of battery, domestic violence, 2 counts of simple battery, domestic violence, and 2 counts of cruelty in the 3rd degree. This is from a June 27, 2022 incident, and the accusation number is 22 CR 005360C. Mr. Jones, you've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod. Ms. McLeod, good afternoon.
Good afternoon, Your Honor.
All right. Ms. Harrison, any priors on Mr. Jones?
6 cycles, last arrest December of 2021 for possession or transport of firearm by convicted felon. That was in Cobb County. It appears to be an open case. He has a 2013 misdemeanor DUI conviction and a 2013 possession of cocaine with intent to distribute, 1 violation of probation within the past 10 years. Nothing further.
Thank you. Ms. Alexander?
Yes, thank you, Judge. As it relates to count 1, battery family violence, the state is going to recommend a $5,000 surety bond. As it relates to count 2, simple battery family violence, a $1,000 surety. Same thing with count 3, Judge, a $1,000 surety. And for the cruelty counts, Judge, $500 each. Of course, surety, making that a total of an $8,000 surety bond with conditions of 2-day anger awareness class, a parenting class, no further contact with the victim in this case. Miss Sinestra Taylor, a stay away from 2960 Middletown Road, Northwest Atlanta, Georgia. Third-party transfer of the children, Judge, and no alcohol, drugs, or weapons while out on bond. Judge, this was an incident that arose in June of this year, June 27th, 2022. Law enforcement were dispatched to that incident location, again, in reference to a dispute. Upon arrival, the victim advised that her boyfriend became upset at her when she wouldn't come home. Eventually, she did return home, Judge, and this defendant essentially poured alcohol on her head and spit on her. That's the basis for the simple battery, Judge. As he was leaving, the defendant then punched the victim in the face 3 times in front of their 2 minor daughters and fled the scene, Judge. The victim was left with a visible knot on her face and swelling. Law enforcement did in fact observe bruising on the victim's face, and the victim, indeed, she provided a photo of the injury, Judge. The state obviously is going to recommend, the $8,000 surety in light of this defendant's history. We do feel he obviously has a significant risk of reoffending. He does pose a significant risk to the victim in this case. And we do feel that this does pose a significant risk of witness intimidation in light of the parties involved. We did reach out to the victim in this case. She did want no further violent contact and to stay away. Judge, the state feels that there has not been an adequate cooling off period, Judge, and so that is why we are recommending what we're recommending.
All right, and she's not on the Zoom, correct?
I do not see.
She should be, Your Honor. She told me she would be.
We can sound for her, Judge, if that's okay.
Sanicia Taylor, Miss Taylor, if you are present, this is the time to unmute your screen and start your video. All right, don't see anyone. You may proceed, Ms. McLeod.
Yes, Your Honor. My client is 32 years old. He is a native of Atlanta. He and Miss Taylor have been in a relationship for some time, and they have 4 minor children together. The children's ages are 4, 3, 2, and 1. My client does not have any violent history in his past, Your Honor. He is gainfully employed as a driver with Amazon. I had the opportunity to speak with Miss Taylor, and she tells me that she is not afraid of my client at all. She said both of them were just having an argument together and it got a little physical. She says that is not the nature of their relationship, and she definitely wants to have contact with him and for him to be around the children. They have lived together and continue to live together since that incident, which happened sometime in June, and there have not been any other issues between them, Your Honor. These are very small children who need their father. I think it would be a disadvantage to the children not to allow them to interact with both of their parents. Based on that, Your Honor, I would ask the court to consider, given his history, which is nonviolent, and the fact that he's gainfully employed and that he has these 4 children, I would ask a signature bond on his behalf, Your Honor, with conditions of no further violent contact with Ms. Taylor, which is what she wants, given that he doesn't have any violent history. Thank you, Your Honor. And I do believe she is here now, Your Honor.
She is, I see her. Ms. Harrison, may I confirm if we have a armed robbery conviction with a subsequent probation violation in this case?
One moment.
I see 2013 probation violations for armed robbery, so I just want to confirm.
There's no armed robbery in his history.
Is this Thomas?
Yes, Thomas Jones Jr.
Thomas Jones
Mhm.
Jr. I've got
He
a,
has, cycle 1 is the DUI, cycle 2 is the felony conviction of the possession of cocaine. Cycle 3 is the probation violation.
this was back in April of 2009.
His cycle starts with 2013.
He's under 32, Your Honor.
How old is he?
32 years old.
Yes, he's 32.
I'm looking at his case on Odyssey, so I see that. So, okay, fine. Anything else, Ms. McLeod?
No, Your Honor, but Ms. Taylor is on the zone, Your Honor.
Yeah. Mm-hmm. Ms. Taylor, my name is Judge Law, and I have to decide what kind of bond Mr. Jones gets, as well as whether he's permitted to return to the home or whether he needs to stay separately from you while this case is pending. So if you'd like to say something, you would need to remove that yellow, that hands up thing. Then you need to unmute your phone. I can't hear you. You are still muted. All right, you're still muted. It's a little button. It's the same as the stop video, but it has got a little microphone. You need to click on that to unmute. It's the same button. All right, while Miss Taylor is trying to figure out her mute button, Miss Harrison, if you can look up this case 09SC 762.
One moment. 09.
SC 76245. Oh, excuse me. I'm going to correct that. 09 SC 79654.
Okay, one moment.
Miss Taylor, I won't be able to address you unless you unmute your device. So I don't know what else to tell you. I mean, if I can't hear you, then I can't hear you. All right. And Miss Alexander, if you could also look up that case, I just need to know whether I'm seeing a different.
Yes,
case.
Judge, I'm looking it up now, but it does appear to be a different defendant.
09 SC 79654.
Yes, Your Honor, I'm looking.
Oh, no. Okay, then this one, 13 PF 002685.
I'm sorry, Judge, 13 PF is in P is in Paul, F is in Frank.
Yes.
Okay.
002685. It's a probation violation. I don't know whether he's a co-defendant.
Gotcha, Judge. I'll look it up.
All right, Miss Taylor, how are we doing? All right.
Your Honor, I had the opportunity to talk with her today just before court, and she tells me that she did not expect any of this to happen. She just had wanted him, they were having an argument, and she just wanted him to leave the house. So she had just asked him to leave the house.
Well, according to the warrant, a lot more happened than just simply leaving the house. So that's my concern.
I understand, Your Honor, but they continued to live together. And this was the end of sometime in June.
Right.
We are now on August 30.
Which is a mere 2 months away.
I understand, Your Honor, but nothing has happened between them since the time. And he definitely does not have a violent history.
Well, that's what I need to confirm.
Okay,
Judge, it does appear to be open, but I'll defer to pretrial.
So the 09 SC case does come up with multiple defendants, and there is a robbery there in 2012, but it does not come up in his GCIC.
I see. Okay.
So he was sentenced March of 2012, 10 years probation.
And that probation case is his?
It's the same name, but there are multiple defendants on that case number. So when you scroll down, he is, I believe, the 4th.
Okay. All right, thank you. On the battery domestic violence, the bond's going to be set at 2,000. On the simple battery and each count of the cruelty charge are going, no, excuse me, the simple battery is going to be 1,000 each. And the cruelty, each count is going to be 500 each. The total bond is going to be 2,345. That's a $5,000 surety bond. No further contact with Sanicia Taylor. He has to stay 200 yards away from Miss Taylor, not communicate and not live with her until further order of the court. He's not to contact her in person, not through a phone, not through a computer device, and even on social media. He may have third-party contact with the 4 minor children in question, and I will allow for a third-party transfer. In other words, Mr. Jones and Miss Taylor do not make the arrangements. There has to be a third party involved so that Miss Taylor can communicate with the third party with regards to pick up and drop off of the 4 children in question. No alcohol, no drugs, no weapons. And Mr. Jones, if you do make bond, I'll require you to do a 6-month domestic violence intervention program as a condition to your bond. And you should begin that program within 90 days of being released on bond. Your next court date will be sent to you at a new address where you live. So within 30 days of being released on bond, make sure that you update the court with your new address. Okay, thank you.
All right, next we have number 11, Mr. Williams.
We have Ishmael Frank Williams. Is that your name, sir?
Yes, ma'am.
All right. Mr. Williams, you have been cited with violating a family violence protective order, and this is from case 22 CR 005364J. The date of incident appears to be August 12th, 2022. You've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod.
Yes, Your Honor.
Any priors, Ms. Harrison?
3 cycles. Last arrest was November of 2019 for aggravated assault with a deadly weapon in Fulton County. That is an open case 20 SC 174032. Nothing further.
All right. Mr. Borgen?
Thank you, Your Honor. The state is asking for a $10,000 surety bond with the conditions of no further contact with Miss Nicole Williams. That's the defendant's mother. Stay away from the incident location. That is Miss Williams's address, 376 Bill Kennedy Way. And MHET, ankle monitor, enrollment in a family violence intervention class. And of course, no guns, drugs, and alcohol while on bond. Your Honor, in this case, Miss Williams had taken out a family violence protective order, which was granted in August 11th of this year. Mr. Williams was present at that hearing, so he did have notice of that protective order. Later that evening, Mr. Williams arrived at the property and was at first banging on some basement windows and then climbed over a patio deck to then bang on some more windows, which obviously frightened Ms. Williams. This original incident that caused Ms. Williams to take out the TPO began on June 17th, where the defendant was using hostile language, slamming doors, and causing Ms. Williams to fear for her safety. Combined that with the aggravated assault with a deadly weapon, that's a 2019 case. Obviously, it's a high-risk felony case, which is one of the reasons why we're coming in so high with this bond recommendation. But he was given PTI and was supposed to be on track to complete certain classes, which this defendant is nowhere near close to completing, which is why he's going to be held on a compliance hearing date later in October. But I guess the general gist is that he's not complying with the TPO that was taken out. He's not complying with the PTI that was given for an aggravated assault with a deadly weapon, which occurred at the same incident location, by the way. And then finally, Ms. Williams indicated that she's worried that this defendant is going to leave the state. He does have a child that lives in Houston, and he indicated actually in court during this protective order hearing that he had intended to leave Georgia to go be with another child. Ms. Williams is here, so of course she can share some good information on what has happened. But because of the violent risk of this defendant, the fact that he hasn't complied with a protective order, hasn't complied with PTI for his aggravated assault with a deadly weapon, that's why we're coming in high with that 10,000 surety and an ankle monitor. But I would like to yield my time to Ms. Williams.
All right. Ms. Nicole Williams, my name is Judge Law. If you would like to add any information with regards to whether you would like Ishmael Williams back in the home or anywhere near you, that's the information I'd like to hear about. And may I place you under oath?
Yes, you may.
All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Do you have the case number for that TPO or the protective order?
I don't have it with me. I mean, it's on my email.
I can retrieve that, Your Honor, real quickly.
Okay, all right. Please tell me about your desire for proximity to Ishmael.
Yes. So my issue with Ishmael, I love him dearly and I'm trying to save his life. He has been examined or basically having a lot of mental health.
And we are not going to get into that. We're not going to get into
I'm just about to object to that, Your Honor.
Right. It's this is private medical information. So we're not going to do that. The whole court proceeding is being recorded and live streamed. So if you believe there are behavioral health issues, okay, we'll make a note of that. But tell me about how safe do you feel with him?
Yes. Well, the issues is the behavioral issues. He is self-medicating himself with drugs and alcohol on a daily basis. And so that is providing some disruption in the home. He is very aggressive towards me. He actually, his daughter is here in Georgia living with me, and I have temporary guardianship of her. So, you know, she's scared of him because of the abusive language. There's, you know, illegal drugs in the house. He also brings homeless people into my home that I do not know, allows them to sleep on my couch, allows them to take showers in my home.
I'm going to ask the witness to limit her testimony to whether she wants contact with my client or not, and it sounds like she does not.
I think I'm not going to assist. Oh, well, I'm going to overrule the objection. But Ms. Williams, so basically you do not want him back in the home and you want him to comply with the protective order. And I found it, Mr. Boger, it's 2022 CB 368676, correct?
Correct, Your Honor.
All right. So it looks like okay. All right. Miss Williams, so it looks like an ex parte order has been temporarily granted on August 11th. And
I'm not sure.
I'm sorry?
I'm not sure what that is. I'm sorry.
You have a temporary protective order that was granted on August 11th.
Correct.
Today is August 12th.
Yes.
All right. Did you file another order in the past?
I have not. No, this is my first one. Yeah, and Ishmael would be homeless. He does have a father in Florida that is willing to take him in, but I know with his felony case, he's not allowed to leave state lines, and he would actually have to request permission to go there. But my hope is that he would want to get, you know, some drug and alcohol rehab treatment, and that's what.
Again, I would object to this line of testimony concerning my client.
Thank you. Thank you, Ms. McLeod. Officer Burgess or Officer Norris, we're going to have to put Mr. Williams' case on deck right now. I can only readdress it later on. I'll have to do a sidebar with Ms. McLeod, Mr. Borger, Ms. Williams, and who else wants to join us? I think Ms. Alexander and
Ms. Ekbo as well.
Ms. Ekbo. Okay.
Sure thing, Judge, that'll be fine.
All right. We're going to address that in a few moments. Can we have the next case, please? Ms. Williams, if you can mute your screen, we need to put you on hold. Thank you.
Got number 4, Mr. Harris.
Thank you. All right, this is position number 4.
Yes, ma'am.
David Allen Harris is accused of simple battery in case number 22 CR 005357J. Mr. Harris, your court date, the date of incident for this misdemeanor offense is August 12, 2022. Ms. Harris, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Ms.
It's me,
JP,
Judge.
Johnson. Ms. Johnson, okay. And any priors, Ms. Harrison?
Second arrest, first arrest was May of 2001 for furnishing to purchase or possession of person below legal age of alcoholic beverage. That was a no pros. He does meet the criteria for UJR pretrial, Judge.
Thank you. Ms. Alexander?
Yes, thank you, Judge. The state is going to recommend a $2,000 surety bond with conditions of a one-day anger awareness class. Absolutely no further contact with Mr. And I'm going to spell it, Judge, A-N-A-S Khan, K-H-A-N. A stay.
Anas Khan, is he here?
Yes, yes, Judge, I believe he is on the Zoom and does want to speak.
Okay.
And Judge, the state will also recommend a stay away from 22 14th Street, Northwest Atlanta, Georgia, which appears to be the Icon Midtown Apartments. But again, I will defer to the victim, as well as no alcohol, drugs, or weapons while out on bond, Judge. Briefly, on August 12th, law enforcement were dispatched to the incident location in reference to a dispute between these two parties. The victim advised that the defendant, his neighbor, approached him essentially about owing him money. When the victim denied owing him anything, he got on the elevator. The defendant then proceeded to follow him and swung his left arm towards him, making, of course, contact with him and causing his phone to shake. The victim, of course, advised the defendant also struck him in the face. Video was taken by the victim, Judge, and confirmed that the defendant was the primary aggressor in this case. The defendant, of course, was later was arrested, and essentially, Judge, we understand that the criminal history in this case isn't as severe as others, Judge, but we do still feel that because that this is a crime of violence, Judge, that a surety bond obviously is warranted in this case, and we do feel that this defendant does pose a risk to the victim. I will let the victim, indicate what conditions he would like to advocate for, Judge, but I believe it's going to be a no further contact and a stay away.
All right. When this warrant was signed by Judge Douglas, he issued a $3,500 surety bond. The booking screen shows that Mr. Harris may have posted that bond. Mr. Harris, have you posted a $3,500 cash bond? It looks like it was posted by Pedro Benitez.
Yeah, I had my friend looking at that for me, so I guess he did. Yeah.
All right. So it appears that bond has been posted.
Okay.
So I'm going to keep it at the $3,500 bond as posted.
Okay.
Looks like it's a cash bond that was posted, so we're going to go with that. And no further contact with Anas Khan. And Mr. Khan, if you could unmute and start your video.
Yes, Your Honor.
All right. How far does he live from you? Different
13
floors?
floors, 13 floors up. Yep.
So what floor are you on?
I'm on 25.
All right. So
Mhm.
he is to have no further contact with Mr. Anas Khan. He cannot be on the same floor level of that building. And if Mr. Khan happens to be in the elevator or in the lobby, Mr. Harris has to stay away from him. He cannot be within 10 yards of Mr. Khan.
Sure.
All right, Mr. Harris, you've posted bond. You can go back and live in the same building. And the way we resolve monetary disputes, I'm not saying this one, I'm just saying the way we resolve monetary disputes is in a courtroom. All right. Okay, it's called a civil case. But in the meantime, you cannot have any other contact with Mr. Khan. You cannot call him. You cannot speak to him through a phone, a computer device, and you definitely cannot discuss him through social media. And you're not allowed to have any alcohol, no illegal drugs, no weapons, and no firearms. And like I said, you have to stay at least 10 yards away from him. So y'all do the measurements. Okay, Mr. Harris, did you have a question about the bond?
Yes, ma'am. Can that include like him not getting on the elevator with me if I'm already on the elevator? Or...
No, sir. The case is against you.
I know, but like, so
I think Mr. Khan is going to use common sense. If he sees you on the elevator, the smart thing is to wait for the next one.
Your Honor,
Yeah.
may I say something here? I did not initiate.
No. This case is against Mr. Harris. All right.
I'm just trying to avoid.
This case is against Mr. Harris. He is under a court order to stay away from you. If he engages in any way to communicate with you, he is going to be the one back in jail, not Mr. Khan. So if Mr. Harris decides to act like smarty pants and decide that he's going to try to engage with you or communicate with you, then the only person who's coming back to jail is going to be David Harris. Do you all understand?
Yes, Your Honor.
Now, Mr. Khan, common sense. Remember what mom always talked about common sense?
You're exactly right.
The elevator, you keep out of the elevator. I'm sure that building has a bunch of elevators.
100%, Your Honor. Therefore,
Exactly.
so yeah.
Okay. Mr. Khan, excuse me, Mr. Harris, your next court date is going to be sent to your address because you're already bonding out. All right. Mr. Khan, did you have any last question?
No, Your Honor. Thank you so much.
All right.
Just say, Judge, if Mr. Khan has any other additional questions, Judge, he can certainly reach out to our victim services.
All right. Excellent. Thank you.
Judge.
Next case.
Thank you, Your
Number
Honor.
5, Mr. Jackson.
Baha Jackson is case 22 CR 005-359Y, accused of battery, domestic violence, and 2 counts of battery, domestic violence from August 12, 2022. Mr. Jackson, you've been advised of your right to remain silent, and your attorney is going to be Ms. Johnston. Okay, let's see now. Ms. Harrison?
11 cycles with history in Georgia, Arkansas, and California. Last arrest was March of 2018 for possession of marijuana less than an ounce in Fulton County. And that case was dead docket. 1 violation in the past 10 years. Nothing further.
Thank you. Ms. Alexander?
Yes, Judge, thank you. As it relates to both counts, Judge, the state's going to recommend a $5,000 surety on each, with a total of a $10,000 surety, Judge, with conditions of a 2-day anger awareness, no further contact whatsoever with Stacy Jackson, a stay away, Judge, from 4725 Walton Crossing Southwest, apartment 3321 South Fulton, a third-party transfer, Judge, of the children, and of course, no alcohol, drugs, or weapons while out on bond. Judge, on August 12th, law enforcement were dispatched to this incident location in reference to some unknown trouble. When they arrived, the victim advised that her husband essentially got mad at her when she wouldn't give her phone to the defendant. This precipitated an argument, Judge, and the victim advised the defendant ran after her using his forearm to choke her around the neck. When the victim advised and that she attempted to escape, she advised that the defendant pushed her to the ground and got on top of her. He then sat on her back, Judge. When the victim called for help, the defendant fled. Law enforcement did observe a bruise on the victim's neck, along with a busted lip and scratches on her nose. Judges, you've already heard from pretrial, this defendant is a multi-state offender with 11 cycles. I'm seeing a crime of violence. In 1996, I am seeing some more recent probation violations. I do see some batteries in the 90s with unknown dispositions out of California. Judge, we do feel that these are significant allegations. These are crimes of violence, Judge. We do feel that the defendant poses a significant risk to the victim in this case, and clearly the community, in light of these, this criminal history, the violent nature of the history, Judge. Our office, did reach out to this victim. She did indicate that she wanted no further violent contact, that this defendant is, a good father, but that their relationship is essentially over. But I did want to note, Judge, that when our office asked, whether this had happened previously, the victim declined to answer. When asked if there were guns in the home, victim declined to answer. Judge, the state is recommending no further contact, again, because this is a crime of violence. And also, Judge, there just has not been any significant cooling down period.
Okay, and he had one warrant for battery.
That's correct, Judge. I added a second count, Judge.
For a different act?
Yes, Judge.
Same time?
Same
date?
It was at the same date, Judge, yes.
Okay.
But at a different point in time.
All right. Ms. Johnson?
Judge, I'd like to start by saying that the victim in this case is Stacy Jackson, and I see that there is a Stacy on the Zoom link. I don't know if that is the same Miss Jackson.
If that's Stacy Jackson and she wishes to address the court, please unmute your screen and start your video. Otherwise, we may proceed, Ms. Johnson.
Yes, Judge, I believe it's the same victim, Judge, but I'm being told she does not want to speak.
Okay.
Mr. Jackson has lived in Georgia for 20 years, since 2005, or almost 20 years, I guess. He is a chef at Kel's Kitchen. He's worked there for 5 years. As the state just mentioned, he is a good father. He cares about being a father, and he does provide for his children. It's important that he is able to bond out so that he can get back to work and continue providing for his family. As the state also just mentioned, the victim is asking for no further violent contact. We would ask for that as well, so that he can return to his home and continue living with his family. He cannot currently afford bond because, as I said, he takes care of 3 different kids. So we would be asking for a signature bond on this case. And that's everything from the defense, Your Honor.
All right. On count 1, bond's going to be set at $2,500. That's a surety bond. On count 2 is going to be a $2,500 signature bond through the jail. No contact with Stacy Jackson, to stay away from the marital home. And I'm assuming that marital home is at the Walton Crossing location.
Yes, Judge, that's what I have.
So he cannot return to the marital home. Within 30 days of making bond, he must update the court with his new address so we can send him his new court date. But presently, his next court date is going to be August 25th. So this is a $5,000 split bond. He would have to go through a surety company for half of that bond. No alcohol, no drugs, no weapons. And once he's released on bond, I'm going to require him to do the family violence intervention program, and he may commence that program within 90 days of being released. All right. I'm sorry, did you say there were minor children as well? All right.
Yes, Judge.
I'll allow for third-party transfer of the children. That can always be modified if a divorce or a separation action is filed in the appropriate superior court.
And may May he return one time with law enforcement to retrieve his belongings?
Yes, he may return to the marital home one time only with a police officer to retrieve his personal belongings. But after that, he has to stay 200 yards away from that location. All right, Mr. Jackson, you have a right to remain silent. That is a constitutional right, because anything you say about the facts of the case, your statements can and will be used against you, as well as make it very difficult for your attorney to represent you. And I'm sure your attorney is going to repeat the same warning, but you have the ultimate right to waive that right to remain silent. So.
I just wanted to say that this is an order that's gonna basically make me homeless and break away from my family. My young daughters depend on me. I've been raising them every single day of their life. We have never had the police call to our home for such an incident. It was a, one-time thing. And I just feel like this is gonna put me in a bad position with work, family, and my daughters. My daughters, they're 17, 15, and 11. And I'm a very important part of their life and their upbringing. They were not at home during this incident. And I don't think they should be punished because of what happened. And this is really going to affect them deeply.
Understood. Mr. Jackson, I appreciate that point. And yes, domestic violence not only affects the defendant and the victim, but it affects the whole family. And it's very unfortunate that you're involved in this. You are legally presumed to be innocent of the charge until the case goes to trial and the prosecution proves the charges against you beyond a reasonable doubt. But that remains one unfortunate fact, that this is an open, pending criminal case against you. And my job is to make sure that not only the bond reflects the appropriate factors, but that also that there is no imminent threat to the victim and to the rest of the family. And under the circumstances, this is the bond. Thank you. That concludes the case.
Okay.
Thank you, Judge.
Judge Law, that concludes all of my cases in front of you this morning or this afternoon, I guess. Sorry. May I be excused?
Yes, you may. You're not involved in the other case that I have to take on sidebar, right?
No, I'm not.
Okay, thank you. Have a good weekend. Take care.
You too. Thank you.
Courtroom 2, do we have, please?
Number 9, Mr. Lindsay.
I have Jalen Lindsay arrested from an August 12, 2022 incident in accusation number 22 CR 005-362-362D. Mr. Lindsay has been accused of driving, fleeing, or attempting to elude an officer, operating a vehicle with no automobile insurance, failure to obey a stop sign, driving a vehicle on a suspended registration, and unlawful purchase or possession of THC oil. Mr. Lindsay, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Mr. Borger, I'm sorry, Ms. Harrison?
Second arrest, first arrest was October of 2011 for theft by shoplifting in Fulton County. No disposition listed on that arrest.
Thank
He
you.
does meet the criteria for UJR pretrial. Nothing further.
Mr. Borger, any objection to a signature bond?
Yes, Your Honor. I would ask that the bond remain the same with the addition of just $1,000. Right now, where the bond is at, it's $2,500 for the driving, attempting to elude. No bond was set for the no insurance charge, so I would ask for $1,000 surety. Failure to obey a stop sign, the bond was set at $1,000 surety. Driving on a suspended registration was set at $1,000 surety, and unlawful possession of THC oil was set at $2,500 surety. So my only addition again would be the $1,000, making it $8,000 surety. Your Honor, the officers were conducting a routine traffic stop. The defendant's registration came back as a suspended license, no insurance. Officers initiated a traffic stop, but the defendant drove away. Officers were able to, of course, just go to the defendant's home where the car was registered, where they found the defendant nearby. The defendant was apprehended and explained that he had thought that his car was going to be repossessed. I guess he was late on some payments and thought the police were coming on behalf of the bank to repossess his car. The concern is that one, he's fleeing from the officers, but two, he's now admitting that he's not even going to comply with the terms of his loan regarding his car. So apparently contracts in the judicial process kind of means nothing to the defendant, or at least he's demonstrated so far, which is why we're coming in at this surety bond. Again, not that high when you itemize it, but because of the multiple charges, it's going to get that high.
All right. And Miss Kim.
Yes, Your Honor. Mr. Lindsay is 28 years old, and he was born and raised here in Georgia. He has one child who is 6 months old, and he has to take care of him. Right now, he has grandma, and he has been raised with his adopted family members, and he has been looking for his job for the last 1 month. He is working at warehouse. He used to work at warehouse, and he used to work at Google place. And if he does not continue his job, that's going to be financially detrimental. He graduated from high school, and this is his first ever offense in terms of driving histories. And we would like to request for signature on bond as pretrial services recommended. And also, he has a high blood pressure that he has to take care of the medicines, so he cannot be at the jail at this point. Thank you, Your Honor.
Oh, I'm sorry to hear that. Okay, on count one, fleeing or attempting to elude, that's going to be $1,000. On no insurance, that's $1,000. Failure to obey a stop sign, that's $1,000. Suspended registration, that's $500, and the THC oil possession is going to be $500. Total bond is going to be set at $4,000. That's going to be a signature bond through pretrial services. Mr. Lindsay will sign up for his bond, but he will report to pretrial once a month. He will be subject to random screens for illegal drugs, including THC or any kind of cannabis derivative. He is not to operate any motor vehicle unless he has a valid driver's license, adequate automobile insurance, and proper registration. His next court date will be sent to him at his current mailing address. He will need to make sure that we have his current address so that a bench warrant won't be issued for him if he fails to appear in court. Thank you.
Thank you very much. Thank you, Your Honor.
Next, we have number 12, Mr. K. Williams.
K. Williams, all righty. Mr. Kendall Williams is accused of theft by taking from July 24th, 2022, case number 22 CR 005-363H. Mr. Williams, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Ms. Harrison?
23 cycles, last arrest, December of 2019 for theft by taken in Fulton County. No disposition listed on that arrest. A 2012 felony conviction, possession of cocaine, and a 2015 theft by shoplifting misdemeanor conviction. 1 failure to appear and 3 violations of probation within the past 10 years. Nothing further to add.
All right, thank you. Mr. Borger?
Thank you, Your Honor. The state's asking for a $2,000 surety bond with the conditions of no further contact with Mr. Manuel Ramirez. Stay away from 960 Trotters Farm. That's Trotters, Trotters Farm Road. Enrollment in the theft prevention class, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, the victim, Mr. Manuel Ramirez, noticed that his air compressor was missing. He checked on his Ring doorbell camera and saw a woman come to inside his garage, take the air compressor and essentially hide it from view. While the air compressor was hidden from view, The co-defendant waited for Mr. Williams to pick her up. She went inside the car with the air compressor, and the rest was left up for the investigation. Officers looked at the Ring doorbell, were able to identify the defendant based off of the vehicle that was driven. The vehicle was registered to Mr. Williams's brother, who did explain to the officers that Mr. Kendall Williams was using the vehicle at the time that the air compressor was stolen. Mr. Kendall Williams, when approached by police in East Point Jail, knew pretty well about this air compressor, knew exactly what they were talking about, knew the co-defendant who helped steal the air compressor. And for those reasons, we think a $2,000 surety bond would be appropriate. Mr. Ramirez is here on the line. I do want to reiterate 24 cycles from this defendant, tools of a crime, weapon and school zone from 1998 that was guilty, theft out of 2012, and that's from Gulf Shores, a theft by shoplifting 2015. So we're getting kind of close to felony territory here. Out of state, he's from Alabama with the Gulf Shores theft arrest. So the state would be asking for a surety bond. And I'll let Mr. Ramirez speak if he would like.
Mr. Ramirez, if you'd like to address the court, you're free to do so. I need to place you under oath. No? Okay, thank you. Ms. Kim?
Yes, Your Honor. Mr. Williams is 46 years old, and he has been here in Georgia for all his life. He has his parents and family members here in Georgia. He has ties to the community, and he has been working as provides lawn services, landscaping services, but he does not have a solid job for last 8 months. And he completed up to 10th grade in the high school and completed GED. Right now he's financially challenged, so $2,000 surety bond will be challenging. And Your Honor, 2019 theft by taking, there was no disposition, and previous ones are kind of remote. And also, my client is not the one who took the air compressor, Your Honor. So we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for a $1,000 surety bond maximum. Thank you, Your Honor.
All right, thank you. Bond is set at $1,000. It's a surety bond. He is to stay away 200 yards away from 960 Trotters Farm Road in Fairburn, Georgia. He's to have no further contact with a Rhonda Clark, and certainly to have no contact with Mr. Manuel Ramirez. He's to stay 200 yards away from Mr. Ramirez and not contact him in any way, form, or manner. Mr. Ramirez, if you need any information on how to proceed next with your case, you would need to contact the Victim Advocates Division at the Solicitor General's Office of Fulton County. Okay? All right, thank you. Our next court date is going to be August 25th. If Mr. Williams makes bond, make sure that we have a current address on him. I guess we do.
Yes, we do, Your Honor.
All right, thank you.
Thank you.
Thank you.
Yes, we have number 7, Ms. Jones.
Zakia Jones, okay. Deputy, with Ms. Jones all in the courtroom and I read their rights?
No, ma'am.
All right. And who's the other person?
Ms. Kirk.
Ms. Kirk, all right. Ms. Jones and Ms. Kirk, just to let you know, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney and one will be appointed to represent you. Ms. Zakia Jones, you have an open case 22 CR 005-3558, accused of simple battery and criminal trespass and damage to property from July 7th, 2022. Ms. Harrison, any priors, please?
9 cycles, last arrest, August of 2020 for a simple battery and criminal trespass in Cobb County. She was convicted on the simple battery. The criminal trespass was dismissed. 2017 theft by shoplifting, and a 2014 disorderly conduct. She does meet the criteria for UJR, Judge. Nothing further.
Thank you. Mr. Morgan?
Thank you, Honor. The state's asking for a $5,000 surety bond. That's $2,500 for each charge. No further contact with Carol Davis. That's spelled Karyl Davis. Stay away from the incident location, 3201 Atlanta Industrial Parkway. That's a daycare center. Enrollment in the anger awareness program, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, Ms. Davis was working out of her daycare facility and explained to Ms. Jones that she was unable to care for her child on that day. This upset Ms. Jones, and she had grabbed a COVID plexiglass divider and threw it at Ms. Davis. We're coming in at this $5,000 surety because, again, we see 9 cycles, simple battery arrest out of 2014, disorderly conduct 2014, battery 2020 out of Cobb, that was guilty. And then again, a driving while license suspended that occurred on the 11th of August. So this has not been a promising month for Ms. Jones. She's been asked not to drive because of the license suspension and has continued to drive. So we do recommend the $5,000 surety.
Ms. Kim?
Yes, Your Honor. Ms. Jones is 32 years old, Your Honor, and Ms. Carol Davis is a counselor at her daughter's camp, and my client clearly denies all the allegations, and we do not object to stay away order and no further contact since they don't have to meet anymore at all. They don't live together. Nothing should be hindering them from contacting. I mean, there's no need to have any contact. And Ms. Jones was born and raised here in Georgia, and she has a 7-year-old daughter, and her family members are all here in Georgia, and she is gainfully employed as a receptionist for the last 2 years. He graduated from high school, and she needs to go back to take care of her daughter. And we would like to request for signature on bond as pretrial services recommended. And if Your Honor is not inclined to give her signature on bond, we would like to request maximum $500, each charge totaling $1,000 good bond. Thank you.
Thank you. Simple battery is going to be $3,500. The criminal trespass and damage is going to be $1,500. That's a $5,000 bond. And that's going to be through, that's going to be a signature bond through pretrial services. Ms. Jones is going to report to pretrial once a month. She's not to consume any alcohol, no illegal drugs, no weapons, and no firearms. She'll be subject to random screens by pretrial officers. If she fails to report, or if she gets arrested again, or fail to comply with the conditions of the bond, the $5,000 signature bond will be revoked and converted to a cash bond only. She is to stay 200 yards away. That's the length of 2 football fields from 3201 Atlanta Industrial Parkway in Atlanta, Georgia, and to have no further contact with Carol Davis. No further contact, Ms. Jones, means that you stay 200 yards away from Ms. Davis. You do not communicate with her through a phone, in person, through a computer, through a third party, and you do not discuss her on social media. If you violate any of the conditions of the bond, please make sure to bring $5,000 with you the next time. Understood? Thank you. Your court date will be sent to you. And the only address we have on file, unless you have a new one, Ms. Kim.
I have a 1145 Lucille Avenue, Your Honor.
That's the one I have. Okay, good.
Thank you.
All right, thank you.
Let's get number 8, Ms. Kirk.
Oh, another thing, with Ms. Jones, she's going to take a 1-day anger awareness program with pretrial. Ms. Holly, if you could just include that, please. Thank you.
Thank you, Your Honor.
All right, Alicia Kimberly Kirk is accused of simple battery from August 12, 2022, case number 22 CR 005-354E. Ms. Kirk, you have been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Ms. Harrison, any priors?
second arrest. First arrest was September of 2021 for aggravated assault and possession of firearm or knife during the commission or attempt to commit certain felonies in Fulton County. That is an open case, 22 SC 181574. Nothing further.
What kind of bond has she got on that case?
I see 10. I'm gonna defer to the court.
Is she on a pretrial bond or?
I have a $10,000 good bond for that case, which is kind of surprising. She shot her husband. It was alleged to have shot her husband.
All right, Mr. Boger. Okay, got that part. I'm glad you corrected that. Okay.
Of course.
All right. All right, Mr. Boger. So what are you recommending in terms of this charge?
Thank you, Your Honor. The state's asking for a $7,000 surety bond with the conditions of no further contact with Margarita Orozco. That last name is spelled Orozco. Stay away from the incident location, 1631 Stanton Road. That's an apartment complex. Enrollment in an anger awareness program along with a parenting class. And no guns, drugs, and alcohol while on bond. Your Honor, in this case, Ms. Orozco and the defendant live in the same apartment complex, and allegedly the children both of their children had gotten into a fight. Ms. Orozco claims that the defendant's daughter had kicked her daughter in the head, and Ms. Orozco wanted to speak with Ms. Kirk about the fight that their children had gotten into. This confrontation really just upset the defendant, and she came out of the apartment. Our victim advocate spoke with Ms. Orozco, who said that the defendant had a knife in her, or not, excuse me, not a knife, had scissors in her hand, ran out of the apartment wielding the scissors. According to the police report, Ms. Orozco was struck in the face by the defendant outside of the apartment complex in front of these children. Of course, the whole discussion was about children fighting, and now we have two parents fighting. Again, we look at this defendant's history, and it already is showing pretty severe violence. Ms. Orozco is on the line. So perhaps she can give her side of the story as well and her feelings about this case. But given the violence, given that this is in front of children, I do think that a $7,000 surety bond would be appropriate.
Ms. Kim?
Yes, Your Honor. Ms. Kirk is actually 36 years old, and we don't want a current open case that is pending to be prejudiced against her because she is presumed to be innocent. There has been no conviction whatsoever. It is still open. She is presenting her case. And we would like to request for signature on bond for this, even though there is an open case. She has 5 children. She resides with 3 of them who are still minors, 11, 10, and 8 years old. And she does not have any other resources to provide financial support for bond outside of her 3 minor children. She has not had a job, and yet she got a new job that starts this coming Monday. And she really wants to continue that job so that way she can continuously take care of minor children. She graduated from high school. She also did 1 year of technical college for medical assistancing. And we would like to request for maximum $1,000 good bond if Your Honor is not inclined to give her signature on bond.
All right.
Thank you.
Ms. Margarita Orozco, my name is Judge Law. If you want to address the court, you would need to unmute your screen and start your video.
Okay. It says that someone disabled my video. You can't start your video because your host had disabled it. I can't start it.
Your Honor, may we please limit her testimony to whether she would like to have a continuous contact? My client has no objection to no further contact, and she will not even go to her building. They are living in a separate building, and my client is willing not to go to her place at all.
All right, I heard you. Thank you. Ms. Orozco, if you'd like to testify, I need to
Yes.
place you under oath. And I'm not going to address the incident itself. I just need to know whether you are comfortable with Ms. Kirk being in the same location as you. All right? So
Okay.
if you want to testify, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, so whether the incident happened or not, how it happened, who hit who, it really doesn't matter at this juncture because we've already got a warrant for the arrest and there's a formal case brought against Ms. Kirk. So the only issue I have to decide is whether you and your family feel safe when you are both in separate buildings.
Yes, because we in separate buildings.
So you feel safe because you're in separate buildings, is that correct?
Yes.
And did the child share the same bus stop as Ms. Kirk's?
Yes.
All right. And so are there occasions when Ms. Kirk and you might be at the bus stop at the same time?
She don't even go outside with her children to the bus stop.
Well, that certainly helps matters. Thank you. Is there anything else you'd like to add with regards to your safety?
No, ma'am.
All right. Thank you, Ms. Orozco. I appreciate you being here. Thank you.
Thank you.
On the simple battery, what's most disturbing is that Ms. Kirk has an open felony case, and it's 3 separate counts of aggravated assault, domestic violence, and possession of a firearm. Yes, that I cannot deem that case to be used to indicate whether she is to be found guilty or not guilty. That is something for a judge or a jury to decide once that case goes to trial. And it'll only be decided if the prosecution, the district attorney's office, proves those charges against Ms. Kirk beyond a reasonable doubt. So that's step aside. But what's concerning is that in less than a year, Ms. Kirk is back in jail on another violent offense. And that is most disturbing. The bond is going to be set at $2,500. It is going to be a surety bond. She is to have no contact with Margarita Orozco and her immediate family members, which means that, and she may continue to reside in her building, but as long as Ms. Orozco and her family members are outside, Ms. Kirk is under an obligation to remain in her building, remain in her apartment. Do you understand, Ms. Kirk?
What about the bus stop? My daughter.
You are not allowed at the bus stop. You can have a third party go take your daughter to the bus stop and then pick her up.
Okay, and if I want to press charges.
Please remain silent.
Then
I would
you
like
I have a
to,
question.
Then you speak to your attorney.
Okay, because I wasn't
I will call you.
I didn't receive I called the police also because my daughter came in crying and I didn't receive
Please,
that.
Miss
Yeah, Ms. Kirk,
please.
your attorney is going to tell you to please be quiet because at this juncture, you're the one who's been arrested. Now, if you believe that you have a valid case against Ms. Orozco, you definitely need to speak to an attorney to decide your next step. And if you discuss this on Zoom, all that's going to happen is going to incriminate you and damage your defenses. Do you understand?
I'll give you a call.
Yeah.
All right.
Thank
Okay.
you.
This is $2,500. It is a surety bond, no contact, and next court date is August 25th.
Thank you, Your Honor.
All right. Other than the young man back there, I'm just going to go down the calendar quickly and then
Yeah.
address that one case.
May I ask about what happened to Mr. Leaks?
Oh, well, that's why I'm going down the calendar and we'll find out. Okay.
Okay.
Position 1, Braggs, is a 2,000 surety bond, reset date August 25th. Position 2, Cochin, is a $6,000 surety, reset date August 25th. Position 3, Graham, is a $5,000, I think that was, a surety bond, reset date August 25th. Position 4, Harris, is a $3,500 cash bond. He bonded out on that and to stay 10 yards away from Mr. Khan. No alcohol, drugs, and weapons. Baja Jackson's a $5,000 split bond, 3 and I think it was 25 and 25.
That's correct, Judge.
Reset date is August 25th. Position 6 is a $5,000 surety bond. Reset date is August 25th. Position 7 Jones is a $5,000 signature bond, further notice. Position 8 is a $2,500 surety bond, reset date August 25th. Position 9, and that's Lindsay, is going to be a $4,000 signature bond through pre-trial, further notice. Unije is a $6,000 split bond, reset date August 25th. 11 Williams is Ishmael is I'm sorry, I didn't write it down.
We're coming back.
That's the one we're going to address. Sorry, that's the one we're going to address. Correct. And Williams Kendall is $1,000 surety bond, reset date August 25th. There is no leaks, Mr. Berger?
Well, he was on today's calendar,
He
and I
might
was
have been on the
curious.
poll sheet. Let's see. Officer Burgess, Officer Norris, do you have any report on leaks?
You want on our sheet or the calendar day?
I didn't have any of those, any of that.
Could you have a booking number, Mr. Berger?
Sure. I mean, my concern is,
Riverside.
If
you have a booking number, I can.
2211935.
2211935. All right, and could you tell me when was he booked in?
I have on the 12th.
Which was yesterday. All right, he's got a $10,000 good bond. And he says the booking is not complete.
It seems like he posted bond.
He's out. Oh,
Is there any way is there like conditions
Oh,
to
he
that
posted
bond?
bond. So
Posted bond.
yeah, he posted bond, so he's not going to be on the calendar.
And Mr. Berger, when they post their own bond, it's just further notice to the next plea and arraignment calendar. And the restrictions would be whatever the magistrate who issued the warrant had put on the warrant.
Like, so the no further contact and things like that, I could find that on the warrant that was issued.
If one was issued. So typically when the magistrate issues the warrant on electronic warrants, they have a special conditions box. If they check those off, those will be in place. So you would need to check the paperwork on the warrant.
Okay. Is that type commonplace? Because I think he's on first offender.
I don't know, but if the judge put a bond on it, then I don't know what happened there. All right. Okay, Mr. Ishmael, if you please hold, I need to go into a sidebar with Miss Alexander, Miss Bridgewater, Miss McLeod, Miss Nicole Williams, ASG ECPO, and Prosecutor Borger. Ms. Alexander, did you want to join us, or you're free to go otherwise?
Yes, Judge, I think I'm good to go. I'll hand it over to ASG Borger.
Oh.
Although this has been fun. It's always good to see you, Judge. It's been a minute.
It's been a minute. You take care. Have a good weekend. Thank you.
Too.
All right, Mr.
Miss Williams, I sent you a request to go to the breakout room.
Miss Williams, is everything okay? You're not in the,
Yes, they asked me to leave the breakout room.
okay, all right, making sure. Thank you.
This is
All right, Judge, I got a little happy.
That's okay, Mr. Jordan. That's okay. All right. We are resuming the case of State versus Ishmael Frank Williams, 22 CR 005364J. Mr. Williams has been alleged to have violated a family violence protective order. The case in which the order was issued is, sorry, Mr. Jordan, let me go ahead. And that's going to be 2022 CB 368676. Mr. Williams, again, I'd just like to remind you that you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you in the treatment of your case. You have a right to an attorney, and the attorney representing you is Ms. Maureen McLeod. Mr. Williams, I'm going to ask you to not say anything until I have made my decision, and then I will give you an opportunity to speak. Do you understand? Officer Norris, if you could please unmute. He doesn't want to. All right. Mr. Williams, again, let me repeat what I said. Let me make my decision, and then I will give you an opportunity to speak. But please remember that anything you say, your statements can and will be used against you, not only in this case, but as well as any other open pending cases against you. Do you understand?
Yes, I know. I just want to address something that you guys said earlier about my case.
I've already said you have a right to waive your, you have a right to remain silent. Do you want to waive that right?
Yeah, I want to waive that right.
All right, then you understand that you risk the chance of incriminating yourself and making it very difficult for your attorney to represent you.
I'm just gonna state facts. So I went to court for my aggravated assault case Thursday, the same day I got arrested. So I went to court, and this guy Max, who says that I have to go to school. That was probably my older judge, Judge Lagura, and we changed judges about a year ago. I'm with Rachel Carnicel now, and she told me that I just need to do community service and a mental health evaluation.
All right, Mr. Williams, I don't want to discuss your felony case.
No, because you guys were going off of that, saying 10,000 just for me knocking on the door.
I'm not going to address the prosecutor's argument.
Yeah, but all I did was just knock on the door, and you guys are saying that this is something that's violent. My mom wasn't hurt. Nobody in the house was hurt.
Okay, so Mr. Williams,
Like,
again,
and
not relevant, not relevant.
I was stabbed. And you got the guy that stabbed me is in the same jail.
Officer Norris,
He
we're
doesn't
going to
have-
place the screen on mute. Thank you. Okay, now, Miss McLeod, you're going to be representing Ishmael Williams. One of the prerequisites of the grant of to bring a case of violation of a family violence protective order is that there must be a legal determination that Mr. Ishmael Williams was legally served with a copy of the protective order. In this particular matter, Judge Alexandra Manning in 2022 CV 368676 did review the petition filed on August 11th, 2022, and did grant the petitioner, Nicole Williams, an ex parte temporary protective order. Based on the sworn testimony received from Ms. Nicole Williams, it appears that when Mr. Williams was attending courtroom proceedings before Superior Court Judge Carnicel, that Mr. Ishmael Williams was also served with a copy of the ex parte protective order while he was in the courtroom, and that the Judge Carnicel explained to him the temporary ex parte temporary protective order, and that there was another member of the courthouse staff in the courtroom that explained to him the protective order. So after listening to this assessment, this court at initial appearance determines that Mr. Ishmael Williams was legally served with the copy of the ex parte temporary protective order as signed by Judge Manning. And hence the charge for a violation of a temporary protective order based on the allegations of the warrant are going to move forward. Based on assessment of the case, Mr. Williams' bond is going to be $3,500. That's going to be a surety bond. He is to have no further contact with Nicole Williams. He's to stay 200 yards away from Nicole Williams, not have any contact with her in person, through a phone, through a computer device, or through a third party. That means, Mr. Williams, you're not to contact Nicole Williams, even from the Fulton County phone systems or through any third party. You're not to consume any illegal drugs. You're not to consume any alcohol, and you're not to possess any weapons or any firearms. Your next court date is going to be August 25th. You are to stay 200 yards away from 376. That address again, I'm so sorry.
The address
Was it Bill
is
something?
376 Bill Kennedy.
Bill Kennedy Way in Atlanta, Georgia. And Miss Holly, if you can make a note of the case number for the temporary protective order in the bond order, which is 2022 C as in cat, B as in Victor, 368676. Right. Miss Williams, if you're listening to this, you must notify the family violence staff, either Miss Amber Free Dericio or Nayeli Delabrado, to indicate that the respondent is currently in the Fulton County Jail, and they will give you a court date for the final hearing in which the individuals appear from the Fulton County Jail. I'm just making an assumption that he will still remain in jail at that time.
Okay.
All right.
And those individuals that you named, how will I get their contact information?
From whomever you emailed your petition.
Okay. Because there was a
Okay,
victim.
I'll put it in the chat to you.
Okay, thank you.
Thank you. All right. Anything else from Ms. McLeod?
No, Your Honor.
All right. Okay. When you send Ms. Delabrado your request for the court date, please make sure that you put down the case number. And you should be able to get that from the documents that you have. Got it? All right, so y'all excuse. Thank you, Mr. Borger, Ms. McLeod, Ms. Ekpo.
You're welcome, Your Honor.
And courtroom 2, we're concluded. Thank you. Thank you, Ms. Ekpo.
Enjoy your weekend, everybody.
I'll try. Everyone have a good one. Thank you. Bye-bye. Holly, I'll be waiting on your bond orders, okay?
Yes, ma'am.
Thank you.
I went to fax them over, so I'm getting ready to send them to you now.
Thank you. Take
You're
care. Bye-bye. Mr. Jordan, thank you very much.
Welcome, Judge. Have a good weekend.
You too. Thank you.